Hello, and welcome to another edition of Coffee Talk with immigration attorney Brian D. Lerner. In this particular episode, I'd like to talk about what happens when you lose in immigration court. Now, a lot of people lose in immigration court, they give up, and they basically go back to their home country or they go into hiding. But that's not the best thing to do. When an immigration judge denies your case, you have the ability to appeal that to the Board of Immigration Appeals, or otherwise known as the BIA. It is basically an appellate agency within Department of Justice, so it's still administrative, it's not judicial. And they decide on all the appeals from all the denials of the immigration courts in every single state in the United States and Puerto Rico and anywhere else there's an immigration court. It all goes to the BIA in Virginia. Now, it's more important than ever to be able to appeal to the BIA these days because what the Trump administration has done is he has taken a lot of the adjudicating abilities away from the judges, have placed them under quota systems, under time systems, have essentially turned them into clerks and rubber stamp machines for a lot of different applications which go forward in immigration law. Now, uh, I know that a lot of the judges don't like that because they like to be a judge, not a rubber stamp clerk. But given that, and be that as it may, the result is there's a lot more denials than there used to be. So, because of that, you have to be able to fight your case up to the BIA to have another chance at trying to win. And while that same scenario exists a bit with the judges at the BIA, at least you get it in front of a bunch of judges, and at least there's another, hopefully, more realistic chance to win. There's other ways to appeal if the BIA denies your case, but when it goes up to the BIA, there's an automatic stay of deportation, meaning you do not have to leave the United States during the pendency of an appeal at the BIA, and immigration cannot take and deport you, at least they're not supposed to, while the BIA case is pending. Now, once the judge issues the decision, you have 30 days in which to submit the notice of appeal. Now, the notice of appeal to the BIA has to have sufficient reasons in which to appeal. And I mean sufficient legal reasons. You cannot submit a notice of appeal that has no legally sufficient reasons and expect to go forward. They will summarily deny your case without even setting it for a briefing schedule. So I can exaggerate. Let's say you find the proper form to do the notice of appeal, you pay the $110, and on it, when it asks essentially why you want to appeal, you say, because I want to stay in the United States. Okay, let's just pretend that's what you said. Well, obviously, there's no legal basis there in which they could rule on anything. There's nothing that indicates what the judge did that was wrong, and therefore, that would for sure be summarily dismissed. You'll essentially get a document back before any briefing schedule saying your case is dismissed, it is legally deficient, and presents no appealable issues. So, as another example, let's say that you appeal a matter, and on the notice of appeal, you put matters such as there was an abuse of discretion, the proper burden of proof was not considered, the evidence was improperly considered, the judge made an error in law in determining qualification for 212C, the judge violated due process by not allowing sufficient testimony, the judge violated due process by denying the right for certain witnesses to testify. I could go on, but now see, that gives a very good reason, an appealable reason to go forward and for it to be briefed and determined if there's a good appealable argument. So, assuming the notice of appeal has the proper reasons on it, then it will be accepted, and you will then get a notice of the briefing schedule where you will have to file an opening brief. And the opening brief is not a time to bring in new evidence and so forth. It's a time to show legally why the judge in the immigration court made the wrong decision. Okay. And once you submit the opening brief, then the opposition, which is immigration, or it'll go to Office of Immigration Litigation there in Washington, D.C., they will oppose your appeal. And then once they oppose it, you have the opportunity to submit a reply brief to address the issues they brought up in their opposition, which need to be addressed. And then, if you have an attorney present, or even if you don't, and you want to orally argue it in front of the BIA, you can select the opportunity to do that, at which point you will have to fly to Virginia, unless you happen to be in Virginia, in order to argue your case. Most of the time, though, you can do it via briefs and opposition and reply briefs to go forward. Now, you, of course, want to make the record as detailed as possible, and you want to make sure you get an immigration attorney who's familiar with doing appellate briefs, because that's where it's all going to lie, and that's where you're either going to win or lose, or that's where you're going to have the issues to be able to go up again. So just remember, sometimes you have to fight a few battles to win the war. So just because you might have lost in immigration court, by no means is an indication you will lose at the Board of Immigration Appeals. Okay, if you like the video, click like, subscribe, and more on the coming weeks. Thank you.